context that when Section 47 was written, the context was that every accused person had a right of appeal.
Justice Theron, we've debated that 10 minutes ago, and I have said twice that it also knew that there is a direct access provision, and it also knew that when the direct access provision is engaged, the outcome is that you have no right of appeal because this court is a final court of appeal.
Now, apart from the Zuma contempt judgment, where that principle emerged from, is there any other authority for that proposition or principle?
No, the Zuma contempt judgment is the binding authority. That's why we refer to it.
Yes, my question is there any other authority?
No, I submit, Justice Theron, there is no need for us to find other authority because you have a binding authority which is recent.
Let me finish my question, please.
All right, I apologize.
Apart from the Zuma contempt judgment, where that principle emerges from, is there any other authority in support of that?
No, we don't rely on any other authority. We rely on the Zuma contempt judgment. We say it is binding, it's recent, you should follow it.
My question was not what you are relying upon, Mr. Ngcukaitobi. My question was, apart from that judgment, is there any other authority?
Nothing that we have found, but we say, and this is my submission, you are bound by the judgment. You can't undermine it because you're undermining your own judgments.
Now, if we look at Section 47, it does not say that in some instances the proviso will not apply. And I understand that to be what the applicant is arguing, that in this case, in the facts of this case, the proviso doesn't come into operation.
Yes, what we say about the proviso, thank you for that question, and hopefully we can go back to the proviso. What we say about the proviso are three things. Firstly, it's a deeming proviso, and a deeming proviso from Chotabai is that it deems things to be what they are not. Secondly, we say a proviso cannot undermine the controlling section. In order to know the full meaning of the section, you've got to look at the controlling section. And thirdly, we say its purpose is to allow an appeal to take place. But once this judgment was granted by this court, that purpose was fulfilled because this court acted as a court of first and last instance.
If we look again at the Electoral Court judgment, paragraph 50.
Same page. Yes, I'm there.
The third sentence.
Third sentence of what?
Paragraph 50.
Yes, I've got that.
Justice Zondi says, this construction which the Commission seeks requires the courts to read in words into Section 47(1)(e), the effect of which will be to exclude the operation of the proviso in Section 47(1)(e) if a person concerned was sentenced by the highest court in the land. What do you say about that?
No, it's wrong, because the effect of what we're contending for is simply this. If a judgment has been given by this court acting under Section 167 as a court of first and final instance, the object of the section, which is finality, has been achieved.
If the legislature envisaged that there would be a class of persons against which the proviso would not apply, shouldn't they have said so?
There is no class of persons from which the proviso doesn't apply. It applies to everyone, including those persons that have been sentenced by the Constitutional Court. It's the other interpretation that creates the arbitrary distinction.
What does the word until mean in the proviso?
Well, it's obvious what it means. It means it's to open up the possibility that the appeal must be finalized, but that possibility has been exhausted once you have made the decision.
Well, Well, it hasn't been exhausted. It wasn't granted. There was no possibility of appeal.
Yes, but
So the proviso never kicks in.
But that's the consequence of the fact that you exercise original power and you exercise direct access power. So what that means is that finality, the section is there to preserve finality, but finality is achieved as soon as this court makes a decision.
On the assumption that Section 47, that the drafters of Section 47 had in mind that every convicted person in sentence has a right of appeal, subject to leave being granted. Let's leave out the possibility of being sentenced